Showing on this episode of the program highlights from the Law Week of the Premier Branch, the Lagos branch of the Nigerian Bar Association. More reactions trail the Abia court judgment on the Electoral Act, plus our weekly recap of the top legal stories. Hello and welcome to the program. I'm Shola Sheyeli. The Law Week is typically an annual event held by various branches of the Nigerian Bar Association to promote public understanding of the law and its role in the society. It's also a week for lawyers to take time away from their practice, gather together, and deliberate on significant issues which impact on their profession, their lives as legal practitioners and judicial officers, as well as the Nigerian nation. And the month of March has been a season of law weeks from different branches of the bar across the country. The Lagos branch, also known as the Premier Branch, commenced its law week from the 18th of March, and one of the major highlights of the week was a two-day plenary session which drew members of the branch and their invited guests to this hall for various conversations bordering on Nigeria's multifaceted crisis. The chairman of the branch, Ikechukwu Uwana, in his opening remarks, noted that the theme of the week, Democracy and Legal Order, Shaping the Future, seeks to cross-fertilize ideas with various professionals on how the polity can be better.
This theme provides us with an opportunity to interrogate our fledgling democracy vis-a-vis the legal order upon which it stands, and provide thoughts on how we can build a greater democratic Nigeria to shape our collective future.
For the governor of Lagos, the legal profession must reinforce its image as the defender of the rights of all citizens, especially ahead of the 2023 elections. The governor was represented by the Attorney General and Commissioner of Justice.
Our government is committed to enhancing the justice delivery system. This administration has supported activities revolved around justice delivery system. To address the infrastructural challenges in the judiciary following the destruction of our courts, we immediately provided alternative courtrooms in Osborn, and we constituted the Rebuild Lagos Trust Fund. This fund are essentially involved with the rebuilding of Igbo-Shere courts. That process has started. The courts building as it stands has been demolished. The contract is split into two. You have the first phase, which is 12 months, and you have the second phase, which is about 24 months. At the end of the day, you're going to have a courtroom. So that before the destruction, you had 18 courtrooms at Igbo-Shere. In the new building, which is going to go to 10 floors, you're going to have 40 courtrooms. You're also going to have a 700-seater capacity hall for valedictory sessions and for events such as this. The courtroom, the new Igbo-Shere courtroom is also going to have cutting-edge legal technology. It's going to eliminate completely the issue of our judges writing in longhand. Also, the courtroom is going to have about 250 parking spaces for lawyers and anybody who uses the court. It's a state-of-the-art building which we know that it will assist the judiciary in their work. This is a testament of our unflinching commitment to access to justice in recognition of the role of the judiciary in enhancing the practice of democracy.
The goodwill message of the Speaker of the Lagos State House of Assembly was read by Honorable Bola Oyishao.
The legislature, the executive, and the judiciary, the tripod on which true democracy stands, must continue to work hand in hand as it is done in Lagos State in order to ensure the shaping of a brighter future. Finally, as the bar and the national general elections are coming, I implore us as ministers in the Temple of Justice to support a smooth transition and not to abuse the electoral process with frivolous petitions, cases, and applications.
Retired Professor of International Law and Jurisprudence, Professor Akin Oyebode, delivered the keynote address. He called on lawyers to steer legal order along the path of democratic values.
We should always remember, though, that V.I. Lenin, Fidel Castro, and Nelson Mandela were lawyers who stood on the barricade of the liberation struggle of their people. Our lawyers should therefore make a conscious choice to depart from self-seeking, self-serving, and self-considered motives in favor of ideals that will ensure life more abundant for the preponderant majority of our people. Many of our people still consider lawyers as liars. They believe that we don't represent their interests. So this is a loud call to the audience to make sure that the liberation of the people should be the touchstone of their legal practice.
After this keynote speech, the Law Week broke into plenary sessions. The first session, which was moderated by Senior Advocate of Nigeria Joe Kerry-Gadzama, dwelt on terrorism, banditry, elections, and good governance.
Banditry, sincerely speaking, has created a situation where we can say Nigeria has become a failed state. Nigeria has become a failed state because how do you explain some gang of people will overrun local governments, will move people from their natural habitat to go into IDP camps? You have people, their farm crops are destroyed, their source of livelihood is cut off. We have a situation where a major highway in Nigeria, Nigerians cannot ply it. That is Abuja-Kaduna highway because of banditry. So to me, banditry has led us to a situation where we must wake up to revive all our security apparatus. And the only way we can do that is there must be proper training. The government must invest in training. Government must invest in surveillance. Government must also equip our courts to prosecute, train train investigators. That is the only way we can have this deterrent. Otherwise, we'll sit down one day and the third mainland will be taken over by bandits. Definitely, you cannot conduct a free and fair election in atmosphere of insecurity.
People have in fact been arrested for terrorism. They have in fact been arrested for banditry when they're not killed. And we don't hear enough about it. And so we tell ourselves that we are in a state of complete hopelessness and a continued downward spiral. And by that way, we take away our hope, we take away our belief that by staying here and standing for something, we actually intend to get something done. I'm wearing this Bring Back Our Girls badge. We're about to see 8 years since Chibok girls were kidnapped. And of course, I will complain and complain. But the fact is that when 276 were abducted, we're now talking about 109. Definitely, if I'm related to one of the 109 who have not been accounted for, I will not give up my campaign. But I will not say that nothing has been done. I will say rather, okay, you've done something, it's not enough, we want some more. I belong to the Oliver Twist school of thought that, and any government will know that that is what its electorate and its people should be, because you can never do enough. It can never be perfect. We will always insist and demand that more should be done. One of the other prayers that I pray is that our soldiers, members of our armed forces, our police and other security agencies should fight the battle against terrorism, insurgency, banditry and mass kidnapping in accordance with not just humanitarian law, but our own human rights laws. Why do I say that? Not because I'm a Pollyanna living in cloud cuckoo land, but because I know that in the end, adherence to those rules is what works. Adherence to those rules is what builds the kind of what we want to see in terms of a legal order, good governance, and so on. And that's why when we talk about Nigeria as a failed state, it's not so much Because the expression failed state to me is it's a bit like genocide. Everybody uses it now for everything that happens. But I would say rather that it is a failure of the state. And it's not what we are seeing now. It's the failure of the state before the problem started to show those who have now turned to banditry, terrorism, insurgency, and mass kidnapping, that there was a better thing that they could aspire to.
Then we go to things like corruption. You know, it's sad to think that someone would apply to become the president of the country and doesn't even have a worksheet of what they want to do. You know, and at the end of the day, everything just looks like people want to be associated with the name and all that it comes with. But no, it should go more than that. I always feel that Nigeria will work, and Nigeria will work when we are ready to get this country to work. We need to look at the kind of people that we are electing into positions of authority. It is so important, it is so key. Because, I mean, if you have no clues what to do in government, you honestly shouldn't be there.
The next plenary session is that of the In-House and Corporate Council Committee, chaired by Ms. Justina Lewa. The session dwelt on the sub-theme governance and the role of the private sector.
The GDP of this country, that is the total output of this country, is $438 billion. And the private consumption and investment and net exports is about 90% of total activity. In other words, the government activity is only 10%. Absolutely. However, it's a very, very important and dominant 10%. If anything is going to happen in this country to change the trajectory of performance, it has to come from the private sector. But the private sector that is parasitic on the public sector, which is dominant and overbearing, will always end up with suboptimal outcomes. So let's understand that. So if you accept to be subservient to a dominant and to a large extent illegitimate dominant partner, which is the government, then the private sector is doomed. Then if you fix the private sector, by implication, you have actually fixed the public sector and fixed society. But if the private sector accepts to be a subservient and suboptimal partner, then there's no hope.
There's something that I really want to impress on today. We've all heard the word sustainability, right? You've heard it, people have different definitions for it. And I'm just here to say for the private sector, as far as we're concerned, this is a gravy train that has moved on. And to explain why it's important for the private sector and why I have hope that this is something that the private sector can help push. Now, sustainability means for any private sector organization, and even a country, right? You want continuity. So if you're a business that has been successful and you want to remain successful for years and years to come, you need to ensure that there's continuity. And as sustainability is concerned, there are three key pillars. Governance being one of those key things. It's just saying, as a business, you've got to ensure that you are not negatively impacting on the environment at large, you're not negatively impacting on your society, and you don't have a negative impact as far as your governance is concerned.
Apart from just corporate governance, the private sector has a role to play in public-private partnerships. I think more and more these days, it would be good, and it has already begun to happen, that government wants to focus on really what they're there to do, which is to set the regulatory frameworks, to set the legislation, to review sector policy, procurement, oversight of projects, and they're focusing there and they're allowing private entities to step in and manage and finance projects. And what does that do? It allows the private sector to do what they do best, and it allows government to do what they do best. So it's very exciting, the upsurge in public-private partnerships. I think we could do more in that regard. I think right now we've worked on roads and airports and seaports. I would like to see more in healthcare, education, the management of our prisons. So I think we're doing good on corporate governance. We can do more on public-private partnerships. I would also like to encourage companies to do a lot more government engagement and be involved in policy formation, because the avenues are there.
We have a situation in our courts, administration of justice. We all know that it's slow in this country. And foreign investors will not want to come if they know that the system of resolution of disputes is very slow. At times it takes years, 7, 10, 15 years to dispose of. As I speak to you now, I have matters of 1980 still pending in my court. You know, that will discourage the investors from coming. But I'm going to profile a suggestion on how to sort this out. In the election tribunals, time frames have been fixed for disposal of election petitions, both at the tribunal, at the Court of Appeal, and in the Supreme Court. And that has greatly worked for us. I think that we should import what we have done there to the regular courts.
At the end of the session, panelists all agreed that the private sector plays a critical role in ensuring accountability and contributing to good governance. Welcome back. Away from that event, reactions have not stopped trailing the recent court judgment on the Electoral Act. We have the views of a few lawyers up next.
I'm in strong support of the judgment from the perspective of the wider meaning of democracy, which means the will of the people. I do not think anyone should be shut out from the democratic space for reasons of non-resignation within a time framework. What I would say is that if you look at the entire Constitution, if you were to interpret the Constitution holistically, what will come out is that those who render public service should resign 30 days before the election. At least we have that expressly stated for certain categories of public officials. So I don't think the ones affecting political appointees should be different. I think requesting them also to resign 30 days before the conduct of any election is also in line with the spirit of the Constitution. Some people have tried to draw a distinction between public service and political appointees. In my view, that distinction is a distinction without a difference. The question you have to ask yourself is, what do political appointees do? The answer, of course, is that they render public service. So, if you were to interpret the word public service in a holistic sense, then you shouldn't exclude anyone who is also rendering one form of public service or the other from that interpretation. I think in the interpretation of the Constitution, we should rather emphasize purposive interpretation. You look at the word public service and expand it to accommodate all kinds of people who render one form of public service or the other. So I think the government, the judgment is salutary, even though the timing and the way it came out might look very suspicious, which is another debate entirely. So I support the judgment to the extent that it allows greater participation. For instance, we have people in there now who are quality-driven, who may be prevented from participation in the political process on account of the Electoral Act. And if you look at that provision of the Electoral Act that has been struck down by this judgment, it is antithetical to the Constitution.
I think it's healthy for our democracy that certain dodgy clauses, I say dodgy because of the timing, are put in proper perspective. The Constitution is very clear as regards election into public office. Section 66, 107, the Constitution has already laid down the requirements. And so what you have is akin to seeking a backdoor approach to amend an already laid down law. So I'm on all fours with the position of the courts. That clause definitely is unconstitutional. And what does Section 1 of the Constitution say? It establishes the supremacy of the Constitution. So let's not get ahead of ourselves. Seeking to disenfranchise certain persons because of political office, it's a bit untidy, especially at this time. The law is already clear. If we want an amendment then let's do it the proper way. But I'm on all fours with the decision of the courts that section is unconstitutional, Section 84 is unconstitutional and should be expunged from the Electoral Act.
Let's now bring you a quick recap of some of the top legal stories in the news.
We begin with the report that the Supreme Court of Nigeria has upheld the deregistration of 22 political parties carried out by the Independent National Electoral Commission, INEC. The parties were among the 74 scrapped in 2020 by INEC following their poor performance in previous elections. Delivering judgment in an appeal instituted by INEC against the judgment of the Court of Appeal, Justice Ejimbi Eko set aside a judgment of the Court of Appeal Abuja Division, which had nullified the deregistration. Justice Eko held that the Court of Appeal, in its own, raised the issue of lack of fair hearing in favor of the 22 scrap parties and arrived at a conclusion without hearing from other parties in the matter. He further upheld that the appeal by INEC as being meritorious and allowed. From the Supreme Court, we move to the Federal High Court sitting in Abuja, which has dismissed a suit by the Attorneys General of the 36 states filed against the federal government, challenging the planned deduction of $418 million from the Federation account to settle debts owed consultants engaged by the states and local governments in relation to the Paris Club refunds. Justice Inyan Eko held that the state attorneys general lacked the legal standing to institute the lawsuit without their governor's consent, and so the suit amounts to an abuse of court process. The court also held that the contention of the plaintiff that it was not a party to the judgment debt did not hold water because the Nigerian Governors Forum and the Association of Local Governments were parties in the suit. Still at the Federal High Court in Abuja, Justice Taiwo has postponed his judgment on the suit filed by the People's Democratic Party, asking to declare the seat of the Cross River State Governor Ben Ayade and his deputy Ivara Esu vacant following their defection to the ruling All Progressives Congress till April the 6th. Though the court did not adduce any reason why it postponed the verdict, it notified the parties about the new date through the cause list. In another case, the same Justice Taiwo sacked 20 lawmakers from Cross River State for unlawful defection from the PDP to the ruling APC. Lawmakers affected comprises 2 from the Federal House of Representatives and 18 in the Cross River State House of Assembly. Justice Taiwo held that the lawmakers, having abandoned the political party that sponsored them to power, ought to vacate their seats. The court said the action of the lawmakers in challenging the competence of the suit is feeble and constitutes an attempt to pull a wool over the eyes of the court. In their defense, the lawmakers had argued that there was a rancor in the PDP which led to their expulsion from the party. The judge, however, held that the defendants had intentions to mislead the court, and he found gaps and loopholes in their defense as they tried to twist events to suit their narratives. This judgment comes nearly 2 weeks after a similar one sacking the Ebonyi State Governor Dave Umahi, his deputy, and members of the State House of Assembly who defected with him from the PDP to the APC. Still in Abuja, the Court of Appeal has upheld the legitimacy of the Senator Aliu Omako-led faction of the Sokoto State chapter of the APC after it struck out a previous judgment of a Federal Capital Territory High Court for acting beyond its territorial jurisdiction. In a ruling, the 3-man panel led by Justice Haruna Samani dismissed the decision of the lower court, which made another faction led by Mai Nasser Asani and his officials authentic executives of the party. The appellate court faulted the FCT High Court judgment delivered on December the 16th, 2021, in favor of Mai Nasser Asani as being a product of forum shopping, adding that the High Court of the Federal Capital Territory lacks the territorial jurisdiction to deal with matters from Sokoto. And we round off in Lagos with the report that the state government has arraigned the driver of the bus rapid transport BRT, Andrew Nice Omini Nikoron, before the State High Court sitting at Tafawa Balewa Square, TBS. He was arraigned on a 4-count charge bordering on rape, conspiracy and murder of his passenger Oluwabamishi Ayanwola. The Lagos State Director of Public Prosecution, Dr. Jide Martins, told Justice Sharifa Shonaiki that Andrew Nice conspired with others now at large and forcefully had sexual intercourse with his 22-year-old passenger, Oluwabamishi Ayanwola, without her consent, after which he murdered her. He also said that the defendant and others still at large on February 26, 2022, unlawfully killed Oluwabamishi by throwing her out of a moving bus at Carter Bridge after having sexual intercourse with her without her consent. The defendant pleaded not guilty to the charge against him. Justice Shonaiki subsequently adjourned the case to May the 9th, 10th, and 11th, 2022 for commencement of trial.
That's the show. Thank you for watching. Please catch up with past episodes on our YouTube page. I'm Shola Sheyeli. See you next week.